Hi, this is Reverend Tony Suarez, and I'm here to talk about our book. And I hope that you'll be able to obtain a copy so we can go through the detail, but I'm trying to give you a synopsis of the important issues in the book. And in this particular section, I'll be talking about Article 1 of the Amendment 1 to the Constitution, Free Exercise Clause, and it reads as follows. And I think it's important to go through it so that you can follow the rest of this conversation. And it says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. There's more to it. It talks about speech and other things, but I want to establish those two clauses, the no law establishing clause or the prohibiting the free exercise clause, because that is it seems to be a contradiction, and it causes a tension in those two clauses as when a government decides to write a law, right? They cannot write a law that would establish a religion, nor can they prohibit you from exercising your religion. So let me give you a simple example, one of the first cases that came up. Initially, when this nation was founded, everyone celebrated Sunday as a day of worship, a day of relaxation. So Congress, the Congresses, the state laws states were passing laws that said you have to close your businesses on Sunday for the Sabbath. And that became a state law. But what about the people who use Saturday as a day of the Sabbath? They brought a lawsuit and said, by you forcing me to close my business on Sunday, you're establishing someone else's religion, not establishing my religion. Therefore, you're prohibiting me from using my religious faith. And that was called the Blue Laws. And so they stopped it, and the Supreme Court ruled that any of these blue laws basically was an establishment of religion, and therefore it would be unconstitutional. If, for example, I said, let's write a law, and this is when I was raised in New York, that you go to assembly and they will read clauses, Bible sections on the Bible every Wednesday at assembly. So by reading, it was official statute by law of the state that on assembly you would read not the Pledge of Allegiance, you would also do a reading from the Bible, whether it's Old Testament or the New Testament. Well, that was challenged by people who are atheists and say, why are you forcing me to listen to the religious beliefs of the Judeo-Christian tradition when I don't believe in any of that? And then I have to listen to that, and I'm going to be ostracized from the other children in the classroom. When the Supreme Court looked at that and said, by you forcing by law, the state of New York is forcing all the school teachers to then read from the Judeo-Christian Bible, you are establishing a religion, and that was found unconstitutional. So now look at the other side, prohibiting the free exercise thereof. What if the state says, at the football game, this is the case is actually cited in my book, at a football game, and the coach goes out and gets everybody on the knee and starts making a prayer, a common prayer, is that establishing religion, or is that prohibiting my free exercise thereof? The court had to look at that and determine, well, if it's an official action, if it's not an official action, what if it's a private action, to determine who is actually establishing this procedure, which may be a violation of someone else's rights. Let's look at this. Let's say, in the case again cited in my book, there is a person who uses her art. She's an artist and she bakes cakes. And what she does with her cakes, she expresses herself, and she became very famous for the beautiful cakes that she made. Well, a gay couple walked into a store. They said they want her to make a cake for them and their wedding, and they gave them the couple, there will be two males on the cake. In that case, the person the cake maker, the business decide, I am not going to make the cake, and you cannot force me because my religious beliefs do not allow me to promote gay and lesbian rights. So the question is, by the state forcing you to do business with everyone, she's got a license to do business in the state, that the state gives us a license, the city has given her a license to do business in the state, does that require you to then forgive or forget your personal religious freedoms that you will not support a gay couple? And that is the tension between, in that particular case, the Supreme Court ruled that the cake maker has an individual right to, and the state cannot force her to practice her, prohibit her from practicing her religion by forcing her to deal with everyone that walks in through her door. There is a clash between her individual rights that cannot be prohibited from practicing religion your way, and the government establishing a religion officially by putting certain laws that look like they're driven by one particular religion versus the other. The same problem comes in schools, whether or not, you know, a public school gets funding because it's a public school, but what happens when you set up a private religious school? And now you're giving money from the private religious school, from the state budget to the private religious school. Are you establishing that religion by giving money from the state to a religious school to establish their religious doctrine? Those are the questions that have to look at too, because they're very difficult. And the government has tests. The courts have tests. The courts look at a balancing between the rights of the establishment versus the prohibition of free exercise. Therefore, the test is in the book. You can look at it, and you may not be happy with the solutions that the courts have come up with, but at least you understand the process by which the courts are using in the constitutional process, the logic that is being used. And if you don't like it, that's why you get to go out there and vote every 2 years. Thanks.